A monumental court ruling is restoring voting rights to tens of thousands of former felons in North Carolina. The preliminary decision allows those with felony convictions to register to vote and cast ballots, even if they are on probation or parole. Several civil rights groups filed a lawsuit arguing the current law was unconstitutional and disproportionately affected Black residents. If the ruling holds, North Carolina would be the only state in the South to automatically restore voting rights after someone leaves prison. For more, I want to bring in Daryl Atkinson. Daryl is the lead attorney on the lawsuit. He's also the co-director of Forward Justice. Daryl, thanks very much for being with us. If you could briefly first walk us through the history of felony disenfranchisement in North Carolina. Why might these rules disproportionately impact Black residents?
Thank you for having me, Elaine. The history of North Carolina's felony disenfranchisement law is steeped in white supremacy, racial terror, and racial discrimination against Black people. Shortly after the Civil War, North Carolina disenfranchised people who were convicted of infamous crimes or an infamous punishment. The infamous punishments included whippings for the crimes that you were convicted of. North Carolina rebels went on a widespread whipping campaign of whipping Black men in advance of the passage of the 15th Amendment to disenfranchise them in advance of that particular constitutional amendment. Then in 1877, North Carolina amended its constitution to apply disenfranchisement to all felonies where previously it had only been for infamous crimes. Now, this is shortly after Black codes were instituted that criminalized Black people for even the most minor offenses. The 1877 legislation is important historically because it put in three major components of the disenfranchisement scheme that survive even until this day. Number one, it applied disenfranchisement to all felonies, not just infamous crimes. Number two, it made it a felony, a crime to vote prior to your rights being restored. That's still the law today. Number three, it instituted a waiting period before you could get your rights restored, thereby enabling you to vote. North Carolina's law today automatically enfranchises folks, but what our expert witness found is that the average term of probation is more than 30 months, which results in people being disenfranchised almost 3 years, even though they're living in the community, paying taxes, taking care of their kids. And this has had a disproportionate impact on Black people, which was its intended purpose. Back in 1876 and 1877, African Americans, for example, comprised 21% of the voting age population, but they represent 42% of the people disenfranchised. In 84 of North Carolina's 100 counties, and those are the number of counties where we had sufficient data to do analysis, the disenfranchisement rate for Black people is more than the disenfranchisement rate for white people. So the law is having exactly the intended effect of its original purpose.
So, Daryl, let me ask you, you were also formerly incarcerated. What impact does this ruling have on you?
I mean, you know, my story of being someone convicted of a first-time nonviolent drug crime shortly in 1996, 2 years after the passage of the 94 crime bill, which eliminated post-secondary educational opportunities for people inside. I went into prison with a high school diploma. I came out with a high school diploma. Fortunate enough for me, I had a loving family that could provide me food, clothing, and shelter, and I was able to piece my life back together. I went back to school and got my associate's degree, my bachelor's degree, my law degree. I'm licensed to practice law in both Minnesota and North Carolina. I've been practicing in North Carolina exclusively around the restoration of the civil and human rights of people who've been in prison and jail. That work took me to the Obama administration. I worked in that administration the second term. But despite all of those accolades, I could not vote in the state of Alabama because I was disenfranchised in that state, the place of my birth. And I had to pay off over a $50,000 fine, something that we introduced into court, how legal financial obligations, the inability to pay off fees and fines, operates like a poll tax for people who are entangled in the criminal justice system, who are trying to get their voting rights back. So I know this problem up close and personal, and it certainly motivates me to try to do the best work that I can on my cases and in behalf of this case.
Daryl, what impact do you expect this ruling to have on the state's upcoming elections, including next year's midterm elections?
Well, it has had, Elaine, a significant impact, not only in upcoming elections, but in past elections. One of our expert witnesses submitted evidence that in 2018, there were 16 statewide and municipal elections where the vote margin of people disenfranchised was larger than the vote margin between the winning and the losing candidate. On the statewide level, we know these things to be true in North Carolina, that our elections are decided by a razor-thin margin. Our governor's race in 2016 was decided by 10,000 votes. Our Chief Justice for the Supreme Court, a race that happened last November, 5.3 million votes cast. It was decided by a mere 401 votes. So we know that the disenfranchisement of tens of thousands of North Carolina residents who are predominantly African American is influencing electoral outcomes in our state. There is no denying that. And it's had an impact in past elections, and the re-enfranchisement of that particular group can have an impact in future elections, whether it be midterms, local school board or county commission, or who's your next district attorney or judge.
It's certainly an issue we're going to continue to follow here on CBSN. Daryl Atkinson. Daryl, thank you very much for your time.
Thank you so much for having me, Elaine.